Now, the president can also enter into another executive agreement whereby Congress will consent, and that's what is called a congressional executive agreement, where basically Congress authorizes the president to negotiate. Now, there currently is an executive agreement, a sole executive agreement that has made the headlines, you might say, and that is an executive agreement entered into between President Obama and the Japanese Prime Minister regarding the troops in Okinawa and relocating them to Hokkaido, as well as removing some of the troops to Guam. That executive agreement there was initially not adhered to by the successor Prime Minister of Japan. Secretary of State Clinton and the Secretary of Defense Gates on record stated to the Japanese government that successor governments are bound for the faithful execution of agreements. And that's what caused the resignation of that Prime Minister. The new Prime Minister was elected, thereby appointing a new Foreign Minister who Secretary of State Clinton met with in Kahala Hilton back in October. So you have executive agreements that continue to exist today, but it has to exist through the sole authority of the president, representing the military or diplomats. For Hawaii, this executive agreement that I'm speaking to exists solely out of the president's authority to correct the problem caused by his diplomat, his ambassador assigned to Hawaii, and the U.S. Marines that landed by order of that diplomat.
As a part of your dissertation, Mr. Sai, in discussing various topics in your dissertation, did you discuss the matter of subject matter jurisdiction?
Yes.
Examine that?
Yes.
And as a part of your dissertation, Mr. Sai, in discussing various topics in your dissertation, did you discuss the matter of subject matter jurisdiction?
Yes.
Examine that?
Yes.
And as a part of your dissertation, what portion it directly addressed that?
Chapter.5.
Okay. And what did it say essentially?
Objection, Your Honor. He's getting into an area that he was not qualified for as a witness.
Any comment?
Your Honor, he has expertise in this area. His master's and a doctorate in this particular area. And in his dissertation, of course, there are various chapters within the dissertation. And he covered this specific subject matter as a part of the dissertation.
I want him to testify as to what his dissertation contained or what it was about, but I'm not going to allow him to make the final opinion as to whether or not subject matter actually exists or not in this case.
Understood. Proceed.
Well, I addressed specifically State of Hawaii versus Lorenzo and Nishitani versus Baker. Also, the other cases that ensued thereafter. What I addressed specifically was what Judge Walter Heen provided in the Intermediate Court of Appeals was that Lorenzo did not provide evidence that the Hawaiian Kingdom continues to exist in accordance with recognized attributes of a state's sovereign nature. That's why I became a part of my dissertation in Chapter 5 on the information that I did research to speak to the continued existence of the Hawaiian Kingdom, which is the evidence that Judge Walter Heen said should have been provided. So my dissertation concluded that no one has been able to provide such evidence, and that's why Nishitani versus Baker and State of Hawaii Lorenzo is always being used as a means to dismiss cases because defendants have not provided the evidence.
Your Honor, objection. I'm lost. I don't see the relevancy of this line of questioning and testimony to the facts of this case. This is an ejectment action of a specific piece of real property within this district. And I just don't see the connection between the testimony and the issues of this case. There has to be some relevancy here, and I've been listening for a while, and I'm still not getting the connection.
He will, Your Honor.
Well, why don't you give us a little idea of where that connection is, instead of going to the whole extent and having Mr. Stone keep objecting as to being no connection between what's going on? Why don't you just give me a little, or Mr. Stone and I, a little map of where we're going, so at least we have an idea.
That's fine. In State versus Lorenzo, there was a ICA decision, and essentially it set forth a test. And if you could provide to the court factual and a legal basis for the continuity of the Kingdom of Hawaii, you would be addressing the question that was addressed in 4 other cases that none of the defendants in those cases addressed. They lost their case. They were claiming to be citizens of the Hawaiian Kingdom, and they lost the case. And the reason why they lost those cases is because they never produced any evidence whatsoever to establish that there was a factual and legal basis for the continuity of the Kingdom of Hawaii. The purpose that with this client here, excuse me, this witness is here today, is to submit the evidence regarding the factual and legal basis for the continuity of the Hawaiian Kingdom, which is the exact question that was asked in State versus Lorenzo, and the test that they're asking us to satisfy. So in order to satisfy that test, to show that we do in fact have evidence to establish a factual and legal basis for the continuity of the Hawaiian Kingdom, we have addressed the very test that the IC has set forth in case law, applicable case law, which permits us now to establish that there is no subject matter jurisdiction because of the existence of the executive agreement between the President and Queen Liliuokalani. But for the executive agreement, we have no factual and legal basis to present to this court to satisfy the Lorenzo test. So this expert witness is here to testify on the evidence that we have to establish there is a legal basis for the continuity of the Kingdom of Hawaii. And his testimony is going to establish that. And the evidence that we are required to satisfy under State versus Lorenzo and Nishitani versus Baker is to do that, just that, is to address that very question, which was never addressed in the other 4 cases where they got thrown out. So we have a specific focus in the testimony presented by Dr. Keanu side to establish and satisfy the requirements as set forth by these applicable statutes.
What does that have to do with this ejectment?
It has, we're saying there's no subject matter jurisdiction, Your Honor, because it's simply it's beyond the constitutional limits of this court. It should be addressed elsewhere, not here. It's a federal matter between 2 sovereigns, and those sovereigns established an executive agreement between the 2 of them. And those matters are outside the jurisdiction of this court, beyond its constitutional limits. And therefore the court has no subject matter jurisdiction. Because we're relying on a federal treaty between two sovereign states. And that treaty is considered the supreme law of the land under the United States Constitution. And we're here to ask this court to honor that treaty, that executive agreement between the 2 sovereigns. And therefore the subject matter is really a federal matter. And it does not allow this court to exercise subject matter jurisdiction.
Mr. Tsai, by some way, establishes that the state of Hawaii doesn't exist, or as he says, factually, then, but not here, then we may not have subject matter jurisdiction. And I think that's the argument Mr. Agard is basically saying.
He's saying that only a federal court could decide the question.
Well, I can tell you
because of that executive agreement, and I'm saying that if that was his argument, he just should have removed this to federal court.
I'll let him ask that question. I'll let you ask that question later on. I'm going to just allow Mr. Agard to continue.
There are actually 2 separate executive agreements, each having different dates. The first date of the executive agreement for the assignment, the Liliuokalani assignment, is January 17, 1893. The second executive agreement, restoring the Hawaiian Kingdom government, is December 18, 1893. That's an 11-month difference. Both are executive agreements entered into under the sole authority of the President of the United States, which falls under, pursuant to U.S. v. Belmont, Pink, and Garamendi, the Supremacy Clause of the United States Constitution.
After the executive agreements were both complete, what happened after that?
Well, in 1894, the U.S. Congress each passed, the Senate and House each passed resolutions politically to render President Cleveland a lame duck, basically politically pressuring the president not to restore the government.